The next matter to come before us this morning is State of Ohio versus Leslie A. Wheeler. The state has waived oral argument this morning. As the appellant, you have 15 minutes to argue. We've read the briefs and we're ready to proceed.
Thank you, Your Honor. May it please the court, my name is James Armstrong and I represent Leslie Wheeler. The court, I know, often goes to high schools and does oral arguments, and this would have been one of the interesting cases I think high school kids would have been interested in because of the fact pattern. We have a robbery at a BP station in Brimfield. We have a Ford Taurus doing 80 miles an hour down the streets of interstate of Akron. Akron police chase the vehicle, car crashes, driver and passenger, according to police testimony, go out their respective doors. The driver gets caught immediately, passenger is not apprehended at the time. The interesting aspect of that fact is there was no physical evidence against the alleged passenger, who was Leslie Wheeler. Corbell Benson was the driver. He was caught, as I said, right away. The only evidence, in fact, against Leslie Wheeler is the testimony of Corbell Benson, who, it came out through Mr. Benson's testimony that he doesn't like Mr. Wheeler, doesn't socialize with Mr. Wheeler, blames Mr. Wheeler for putting his brother in jail for 9 years, but somehow were together to commit a robbery, which is somewhat difficult to believe that you would commit a robbery with somebody you don't like and thinks ratted out your brother. Hardly somebody you would trust to get involved in such a situation. I said there was no physical evidence. There were videos and photographs of somebody wearing a jacket, a hoodie, a baseball cap, and glasses at 2 o'clock in the morning. Certainly nothing that somebody should have been able to make a positive identification. I was concerned in reading the transcript that, one, that it was allowed because of Evidence Rule 403, that the prejudicial nature of showing a robbery could have possibly taint the jury. I'm more concerned about what I consider the due process violation in the trial judge, who I have an immense amount of respect for, not clarifying that when she said that allowed it for identification purposes, not stressing that the court in allowing this is not saying that the defendant is the person in the video. It's up to you to decide whether he's in the video. The court is not making a determination. Instead, the court pretty much said this is being allowed for the sole purpose of identification.
Was an objection made, or was a request made to the court to clarify that issue?
I don't think that specific matter. It was the video itself was objected to.
Right.
That was objected to. So I don't think we're here on a plain air. But with regard to the instruction, I don't believe the specific instruction was objected to. But the video itself was objected to based on the nature of the prejudicial impact of that. And there's a lot of concerns regarding that, namely that if you show somebody a video of a robbery with a gun, which is what it was, the jury's sitting there looking at a robbery. Well, they're not there on a robbery. They're there on whether a weapon under disability was taking place. Well, what do we know? We know that the passenger, or Mr. Wheeler, the alleged passenger, was never found in the car, was not found at the time, was arrested weeks later. And based on what Mr. Benson told him. And that's how Mr. Wheeler ended up being tried for this issue, which is the reason so often when we do appeals on criminal matters, we bring up the nature of insufficiency evidence or manifest weight of the evidence. In this case, and I don't want to say in the other cases I bring it up it's not true, but in this case it really jumped out at me. When I'm looking at the only evidence against him is somebody who, on the stand, under oath, says, yeah, I don't really like this guy. He ratted my brother out.
Well, let's assume that we didn't have a video. And you just had a police chase. The dash cam video, as I understand, which just shows the passenger running away from the vehicle, but apparently it's not clear enough to make the identification. And you have the co-defendant who said, okay, you caught me red-handed, I was the driver and he was the person who went in. No video at all. And the jury credits the testimony of the driver. And the court gives the instruction about, you know, co-conspirators and all of that. Where's the error on appeal? Where the trier of fact chooses to believe the testimony. I mean, we have all kinds of criminal cases where you don't have any physical evidence.
Well, that's true, Your Honor. In this case, the actual physical evidence almost helps exonerate Mr. Wheeler based on the fact that the person in the video was holding a gun in his right hand, and Mr. Wheeler had a cast on his right hand at the time that this robbery at BP took place.
Did he testify to that?
That was what was testified. That's in the record.
I understand that, but my question is, as I read the briefs, what came to my mind is that, again, the trier of fact has to determine credibility. If somebody testified to that, other than a physician or the person who treated him and so on and so forth, trier of fact could have chosen to believe that or not, that he had a cast on his hand.
Judge Moore, I agree with you. And it's one of the reasons why I was forced to do what I don't like to do, and that's cite ineffective assistance of counsel. The arguments that I presented to you in the first few minutes of this argument were not presented in closing to the jury. And I have immense amount of respect for our profession, but I quite candidly don't understand it. The trial counsel held up a picture of the robbery and essentially said, and I put it in my,
It might be him.
It might be him. This might be Leslie. I honestly can't tell. And I sat around him many, many times in the past couple of months, and I don't know. I honestly don't know. I don't know if that is him or not. He tells me it is not. Then he goes on to say, what I will say is that in the very, very narrow focus, even if that is Leslie in Portage County carrying a gun, that's not evidence of him having a weapon under disability in Summit County. That's outside the jurisdiction of Summit County. When your client testifies, it says he was wearing a cast. When the video shows the person holding a gun in the right hand, when the video shows a person, and the only thing you really can tell by the video, the photographs, is that it's an African American. That's pretty much the extent of the evidence, and you pretty much hold it up and say, well, I don't know if that's my client. But if you sit there and you go through the best arguments for your client, they weren't in the closing. And this is one of those unique cases. Usually, or frequently, I'll have assignment of error, and then I have a second assignment of error that may be unrelated to one of the other assignment of errors. Here, they all seemingly overlap. We have the insufficiency of the evidence, we have manifest weight of the evidence, we have the ineffective assistance of counsel, and we have the instruction with regard to the video with the identification. They all overlap in this case, which is why I raised the due process concern with regard to the identification. So if it seems like I'm jumping around, they all overlap. And when you take it all in context and not separate it out, there's real problems with what happened at the trial with regard to whether Mr. Wheeler actually got a fair trial, whether the jury lost their way. Now, I respect the question with regard, well, without the video, would they be free to believe it? The answer to that question is, of course they would be. But when you factor in that they did have the video, they did have the stills, you did have the testimony about the cast, you did have the idea that this person at 2 o'clock in the morning was wearing the hoodie, glasses, and a baseball cap. I think in the testimony there's also that the person in that video actually meets the description of Corporal Benson, the person who actually implicated Leslie Wheeler. You throw in the fact that he testifies that Leslie Wheeler isn't even liked by this person, that he thinks he's a rat. I believe those were his exact words, that he ratted him out, quote unquote. And all of a sudden we're supposed to believe that based on that testimony and video and pictures that you can't make out, and the fact that my client says he had a cast on and the person's holding the gun in the right hand, which indicates that's highly unlikely. And you figure that you have a video with ID where the judge, I think the word was Judge Callahan, Had she said the trial court is not making a judgment whether this in fact is him, the prosecutor is asking and trying to argue identification, and you throw in the fact that the defense counsel at trial doesn't raise the very arguments that I point to the fact show that he not only should have been found not guilty, but at a minimum, there's a serious question of whether Corbin Benson even should have even come close to being believed, because what he testified to, based on his bias against him, and the pictures, indicate that he might have been making this up.
Well, except that you're leaving out one important factor from my reading of the briefs, and that is that one of the officers who apparently had had contact with your client identified him from the still photograph at the gas station.
The still photograph taken at 2 o'clock in the morning with the hoodie, the glasses, baseball cap?
That's what I read in the state's brief. Maybe I have this confused with another one, but...
I don't recall that. I'm not saying it's not in the brief. I honestly don't recall that. If such a statement is made, you have to wonder if the police officer is trying to protect an arrest, because that calls seriously into question how you make a positive ID from those photographs.
On page 4 of the state's brief, it says Officer Crockett acknowledged that he could not identify Wheeler from the dash cam video. However, he explained that he was able to identify Wheeler in the still frames from the Speedway video footage. So it's not just your client's credibility versus the other gentleman, the driver. And that, in my mind, as I read these briefs, went to the issue of the trial court's instruction of, well, first of all, admitting the video into evidence, and then giving instruction regarding identification, because the officer said, yeah, I can identify.
Okay, so he can't identify him from the officer can't identify him from the dash cam. Didn't apprehend him at the time. And these are all part of the record. Dark photographs taken in the wee small hours of the morning at the BP station over in the other county. He makes a positive ID. I mean, forgive me, Your Honor, I have to suspend all reasonable belief to come up with that conclusion with regard to the officer. And just because they have a gun and a badge doesn't mean they can be necessarily believed. And when you testify to something that doesn't make any sense, when you're testifying, yeah, that's him, and the photographs pretty much can be pretty much anybody, I find that highly, let's just call me skeptical with regard to that. It's the reason why Mr. Wheeler deserves a new trial. Between all that has happened at the trial court, based on the fact that these are all very good questions, Judge Moore. I would like to have seen some more inquiry about how can you do that. I mean, I wasn't quite honestly with your question. I wasn't, prepared for the answer to the question, but in a matter of 1 minute, I came up with a plausible explanation that I wish the trial counsel would have done. And again, I don't.
Well, we haven't seen the transcript, but we'll certainly be looking to see if those questions were asked.
I don't recall that in the transcript, Your Honor. Forgive me, I should have double-checked the brief and follow up on that. But I don't recall that, and I just think when you look at this case, in totality of the case, with regard to all that happened, at a minimum, Mr. Wheeler should have this conviction reversed, and at a minimum, a new trial ordered. I believe that's what due process would require because of the mistakes, or quite honestly, things that we could have done a little bit better at the trial court. I think the world of trial judges, I know at least 2 of you used to be trial judges. You call balls and strikes, and you got to make a decision when you're making the decision. I understand that. A lot of times when you look at the transcript, be it on the appellate bench or be at appellate counsel, you have the opportunity to look back and actually reflect on the decision being made, and you have time to actually to reflect on that decision, where at the time, I just go back to when I was in magistrate juvenile court, when somebody made an objection, I didn't have time to look up Wegmans to find out Wigmeyer to make sure it made sense. I just had to make the decision. So I respect that fact. However, we are looking for due process. We are making sure not only the guilty people are convicted, but also innocent people that are not convicted. And if there is a question, it should side with the accused, not with the state. And in this case, I'd ask the court to reverse the matter and send it back to the trial court for a new trial on this matter. And that's what I'm asking for.
Thank you, Counsel. I regret to inform you that you've reached the end of your 15 minutes of allotted time today.
Well, thank you very much.
Thank you for your presentation this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website, which you can link to through our website.
Thank you.